welcome back to the Tim Teaches podcast. I'm your host, Tim McCoy. Today I'm joined by Tanawa Downing. He is a Naval Special Operations veteran and dedicated to civil rights and advocacy. He is the chief legal strategist behind the We Shall Be Free tour, a movement emphasizing equality and empowerment. The tour plans to hold 32 press conferences across state capitals and major cities over 40 days, culminating in presenting oral arguments to the United States Supreme Court. Sir, welcome to Tim Teaches. I appreciate you jumping on and can't wait to hear what you got going on.
Thank you so much for having me, and thank you for letting me speak to your audience, because this is really important stuff. It's a really big issue. Yeah.
So you're obviously involved in some very large advocacy right now. I haven't dug into it too much, but I kind of like to keep it that way, because then I can be off the cuff and we can just go from there. So what's kind of the overall,
Sure.
case that's going on?
So we have built now what will be the biggest civil rights case in American history, and I know that sounds strange, especially since nobody's. What you got to remember is that when the people are silent, we give our consent. We permit government to do things to us that they would not otherwise be able to do, because we don't speak up, speak out, and demand they do it right. But when government's silent, that is an indication of guilt, because government cannot refute a criminal accusation. And so today, what we're doing to get into the court to be heard, and we're at the United States Supreme Court. We've been through all the state courts. We've been all the way through the federal circuit. We're now sitting at the United States Supreme Court. We're bringing about the awareness and understanding of the people. I've been back and forth across country 19 times over the last 18 months, telling people about these issues, raising the awareness so we can actually have what's necessary to force it into that jurisdiction and be heard, because this is a big problem. But we win on the indictment by a grand jury issue, or the absence thereof, because this is a big problem. But absent the Constitution, there's nothing that connects Florida to Alaska or California. There's nothing but the Constitution. That's what creates the Union and all the harmony. So these states, when they joined the Union, they gave up their sovereignty to subject themselves to the supremacy of the Constitution. And that's a very, very important thing to understand, because when a state chooses to enact its own alternative legislation and then substitutes it for the guarantees of the Constitution, that's going to be a problem, because that's going to lead to, of course, a breakdown of the Union. And we actually today have 13 states that have enacted just that, a provision in their inferior state constitutions that function directly to the contrary of the United States Constitution. Now we have a supremacy issue. So this grand jury issue, it originates from Clause 1 of Amendment 5. I don't think that anybody would argue with me that Amendment 5 is part of the Bill of Rights. It was ratified by the people and adopted on December 15th, 1791, in all intents and purposes. It is part of the Constitution. And as a result, those obligations that are there are to be preserved for the individual liberties of the people. The government must make sure that they provide those rights, and if they don't, then they're acting unconstitutionally. And anytime government acts unconstitutionally, what it's going to produce is unconstitutional. So Clause 1 of Amendment 5, what it says no person shall be held to answer for a capital or otherwise infamous crime unless on presentment or indictment of a grand jury. Now it's clear, you got to have an indictment by a grand jury before arresting someone and holding them over for a capital or an infamous crime. Now a capital crime is any crime that's punishable by death. It's pretty easy. But an infamous crime is defined by Title 18, subsection 4083, as any crime punishable by more than 1 year imprisonment in a penitentiary. So if the crime can get you more than 1 year, that would be an infamous crime. That's the very definition of it. And it's not the amount of time that you get sentenced to, it's the amount of time you can be sentenced to. Because if you get sentenced to 3 months, but you could have gotten 5 years, it would still be of infamous nature, because the arrest is what derives you can't be held to answer for that. So the arrest, and that point of the arrest, what the offense would be, would drive the infamous nature. And so our primary respondent in this case is the state of Washington. And so the state of Washington is its inferior constitution, Article 1, Section 26 says, no grand jury shall be drawn or summoned in any county. So now we have a state that has a provision in its inferior constitution that functions directly to the contrary of the United States Constitution. And now we need to determine which law is supreme. So when the state did do that, unfortunately, and then they started going out and enforcing that particular law that was contrary to the Constitution of the United States, everything that they're doing is going to be unconstitutional, because if that arrest derives from an unconstitutional act because the prosecuting attorney relied upon an inferior state law to abridge an obligation that they have in the Constitution, and thus not preserving the rights and liberties of the people, then what you produced is unconstitutional. In the history of the state of Washington, they've never convicted a person legally and lawfully consistent with the procedures and processes established and codified in the Constitution of the United States. That's a big deal. But it gets a lot bigger because there's 13 states across the country that do not conduct a grand jury. Then there's another 28 states that only do it partially. And what their constitution, such as the Oklahoma State Constitution, I'm in Oklahoma right now. Oklahoma's Constitution, Article 2, Section 17 says that the prosecuting attorney can charge by information or indictment by their discretion. So the problem there is that the state of Oklahoma has permitted their prosecuting attorneys to use their discretion to decide who's going to get a constitutional right and who does not. And that's a violation of the 14th Amendment's Equal Protection Clause. This is a really, really, really big deal. There are more than 700,000 people across America that are illegally and unconstitutionally imprisoned on direct facial constitutional violations.
So just so I'm clear, like Washington is not using a grand jury to indict people to send them.
They do not.
I'm in Oregon, and I was in law enforcement. And,
yeah.
I mean, on a felony charge, we have to present it to a grand jury for it to be
constitutional.
Pushed into court. Yeah,
right.
Yeah.
But Connecticut,
there were states doing this.
Yes. Washington State does not conduct a grand jury. Connecticut does not conduct a grand jury. Pennsylvania, Michigan, these are states that are acting in direct willful defiance of the laws of the United States and the will of the people.